We do not know of that. And unfortunately, my lords, I ask you to kindly restrain him from taking that route.
With your kind permission, Your Honor.
Please sit down. Please sit down. We want you to know that we have rendered ourselves in this matter. We have rendered ourselves in this matter, and we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dedlo Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond, and then we'll make a ruling.
My Lord, I was to also, you indicated that two people, and I was prepared kindly to make an application.
Continue, Dr. Kamuna.
No, my Lord, I'm actually showing one sentence. When you read the book, I have referred to authorities in America. The judges have made a finding along this line. Yes, this is the people, so and so is guilty. But we cannot go ahead. We shall be held. So that's all I'm saying to you. You have heard, you have come up with a very, if I may say so, a ruling full of jurisprudence, and particularly my land, Lord Gachagua has come up with something that I had not thought of very much at all. But all I'm saying to you that you agree, but you still have the discretion to say that, look, we are not doing, these are our findings, but still we are going ahead to give conservative orders for so many days or so many weeks. So you still have that discretion for the sake of the country. Thank you.
My Lord, in brief response.
May I kindly, my name is Sam Nyaberi. I appear for the 9th petitioner in the second cohort. My Lord, I stand to make an application for stay of the orders that have been issued this afternoon relating to the application that was before you, and having keenly listened and internalized the import of that ruling or order, my Lord, we wish to move the court, much as we have that opportunity by way of the orders that were given, that we were given right to appeal, that pending the appeal, pending the lodging of the appeal, my Lord, my Lords and my Lady, you allow us that opportunity of stay so that we can ventilate our issues before the appellate court. My Lord, what informs this application is that there is an apparent risk by the fill-up of the position of the Deputy President, and in our petition, we had named the Professor Kithure Kindiki as a party in the petition that we had filed for the 9th petitioners. So that, my Lord, having analyzed and internalized that, we feel that the petition, in the fullness of time, when the court is going to process it, we will be dealing with an issue that perhaps will compromise the rights of the 9th petitioner who has moved the court. And, my Lord, the other issue is that there is a period within which the respondents, if they have to move, they have to fill up that position of the Deputy President. So that, my Lord, there is no any prejudice that will be occasioned to the second respondent if the orders of stay gets issued, because by close of business today, my Lord, we are going to lodge the notice, and that notice by itself acts as an appeal, and in the fullness of time, we shall be processing the application before the appellate court for appropriate orders to issue. My Lord, I therefore associate myself with my colleagues on the application for stay so that we don't have the proceedings before you in the fullness of time when we come to canvass the petition to be rendered nugatory or academic. My Lord, you have the discretion, and we ask and beseech you to exercise that discretion in the favor of the 9th petition. Thank you, my Lord.
My Lord, I would like to make an application under Article 1B one directly. My lady. My lords and my lady, we are thankful for your ruling today and the lengthy explanations and court case that has gone into it. Unfortunately, my lords and my lady, it seems that some people are being favored over us, and in this matter, it is the state or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024, and we thought that we would be enjoined as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to ventilate our issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November, so at least we get a fair chance, a fair fighting chance as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that the regardless side has asked for 7 days to appeal. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners, and others will just be thrown under the bus and into the darkness. Thank you.
My lord, if I may respond, my lord.
Sorry, just a minute. Can you just clarify your application? You say is dated the 8th of October?
8th of October 2024.
Substance of the application?
It's petition E541 of 2024. We were seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
Fiona, maybe with your kind permission.
Let me clarify. Is that the matter in which you are appearing with Dr. Eboso?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you, I did that. And you and Dr. Bosso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You are
Yes.
petitioners in cohort number 1. And we directed everybody to get into the CTS system, and whoever has a problem to get in touch with the deputy registrar. So it is not right, Ms. Wanjiru, to claim that you have not been enjoined in these proceedings. You have been enjoined. You are a party, and that is why we allowed Dr. Bosso to address the court, even yourself to address. So you are a party. You are a party. That one I can assure you.
My lord, we were not entitled to the right of enjoinder, and we had points that we wanted to defend against the respondent side. So we're just finding it very difficult that due process is not being followed in our instance, as we applied even before both parties on the 8th of October 2024. They came to court on the 18th, 10 days after us, and they have still been granted audience before us, and we were told we're going to be in cohort 1, and then cohort 1, this application has already overtaken cohort 1. We're now being told to come next week, after the swearing in would have been gone through, and after numerous rights would have been violated that we have raised.
I think, Ms. Wanjiru, what you just need to do is just get into the CTS, get all the directions. There's every direction. There's a reason why we came up with cohort 1 application petitions and cohort 2 applications.
Yes, my lord.
So I think we may not wish to respond on whether you are discriminated or not, but we are so sure you are not discriminated,
my lord,
because there are proper directions in respect of every cohort and every matter before us.
My lord,
Kindly take time to go through the CTS. Yes.
My lord, if I may.
Thank you. This court had made directions on this issue. We said there are only 2 applications before this court right now, and those are 2 applications which will be responded to. We have applications. We are finished with this side.
You have not spoken on behalf of the second petitioner.
my lord, that we would like an opportunity to respond to both applications that are being brought today.
Maybe I can say one thing, just on behalf of the second petitioner. My name is Kimotho Teresia Wanjiru Makazi.
Kerugoya.
Yes, there's Kimotho, the company advocates Kerugoya. I just wish to say we welcome the ruling. However, there are some bits that we feel aggrieved and we wish to appeal. And therefore, as we do the notice of appeal, we are praying that we are in support of the issue for injunction, no the issue for stay, which the court may say it's a negative order, but we are saying pending the time we do the appeal, at least the status quo be maintained. And also we wish to say that there was an issue that the Court of Appeal today, application for stay, that is not true. We were told to serve, parties were not all served, and that's the reason why we were given another date. So therefore we are in support of these two applications that have been made today.
Thank you.
Wanjiru,
Let's Wanjiru also. Mr. Dr. Eboso, please sit down. Please sit down.
My lord, this court,
Please sit down. Please sit down.
will I be given a chance to speak?
Please sit down. Ms. Wanjiru, proceed.
Yes, my lord. As a young woman, I'm under 35, my lord. I'm actually 35. I'm a youth and I have a disability. And we're the only ones, I think, on the platform that check that we have a disability, my lords and my lady. Our constitution, Article 1.1, has to count for something. Because it was intended for us to come to courts directly.
Please
when we
respond
feel
to the
afflicted.
application. Support, make the application.
Yes, my lord, I'm in support of the
Yes.
application. Mr. Biased.
my lord, finally. My lord, in response to the two applications, or yours is also an application. Yes, my lord, in response to the application by my learned friend, Mr. Ochiel, future senior counsel, and my learned friend, Mr. Ndegwa Njiro, I wish to set as follows, my lord. My lord, number one, the Madhu paper order sought by my learned friend fall on the basis of the following principles. Number one, my lord, there is already an appeal that has been filed in the Court of Appeal, and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my lord, a party can only apply for stay in the Court of Appeal. That's point number one. My lord, point number two, ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My lord, that matter therefore, or the applications made are therefore res judicata, in the sense that a determination has been made, and this court cannot go back and approbate and reprobate at the same time. You cannot deny an order and then purport to issue the order again. Point number three, my lord. My lord, rules 23 and 24 of the Mutunga rules as presented before you, together with an application by my learned friend on substantive issues touching on actions that may be undertaken subsequent to this, including, my lord, the qualifications of the Deputy President nominee, Kithure Kindiki, can only be brought to this court, my lord, through one, either a new petition and a new application, or two, my lord, through an application for review. The only avenue that Mr. Ndegwa can bring all the issues that he has spoken to this afternoon are applications through review. No application for review or setting aside has been filed before this court by Mr. Ndegwa. And therefore it is inconceivable, my lord, that this court would entertain the application brought on several grounds, my lord, including grounds challenging the suitability or otherwise of the Deputy President nominee. My Lord, lastly, and because my learned friend will submit further, once a court has delivered a ruling, my Lord, the justice of the cause is that consequential processes can be undertaken given that there are no orders in place. And that is not for the court to be part of or to control. That is for other parties, probably not before this court, my Lord. My Lord, what you have done is dismissed the application of conservative orders. So that's a negative order. The court cannot be invited to review or to stay a negative order that has dismissed an application. And the negative order again goes to the application by Kimotho and Company Advocates from Kerugoya, who has also sought to stay your orders. Yet, all that application had, my Lord, was for the former Deputy President, former underlined, to apologize to NIS. Surely, Kimotho, you can do better. My Lord, I'll invite my learned friend to go.
You are protected. You are protected.
No, Mrs. Kimotho and Company.
Yes, my Lord, my name is Muthomi Tenkolu for the second interested party. I have listened very keenly to the two applications, and the issues for you to weigh in your mind are as follows. One, if the outcome they seek through these two applications was declined by the Court of Appeal, not yesterday, but today morning, can this court, being a court lower than the Court of Appeal, on the very same day be seized of an application that result in the very outcome?
Lordship, may I kindly bring it to your attention that counsel has a duty to this court to speak the truth. Being an officer of this court, being a doctor and a teacher of the law, he understands the duty that he has towards you and towards the law, and the fidelity to the law. It is not true that an application was dismissed. It is true that parties were told to serve. So let him submit on the premises of facts and not the premises of presumptions and with the intentions to mislead this court. And if it was declined, let him bring the orders.
My Lord, I think it's an issue of semantics. I come from a community that is not an expert in the English language, but whatever you call it, the point is this. The effect of you granting either of the two applications would be to contradict a decision by the Court of Appeal today morning, not to grant similar applications. That cannot be denied in good faith.
We are objecting to this. They are misleading. I was before the Court of Appeal.
You were in a car. You were in a car in the morning.
My Lord, the Court of Appeal is a court of record. I don't want to belabor this point. Let me move to my next point. The Court of Appeal is a court of record, and I'm sure the court has access to that record. Two, my Lord, it is not like Kindiki was nominated yesterday or the day before yesterday. He was nominated several days ago. If the applications now being made were made in good faith, they should have made a formal application several days ago, which would have been on record, which we would have had the opportunity to respond to. You are now being invited by submissions from the bar without a formal application to grant some relief, supposedly on the ground that Kindiki is unsuitable. That cannot be proper, my Lord, especially when the nomination of Kindiki wasn't made yesterday or last night. They had noticed for several days. If they have any issues with the suitability, they would have filed an application on that regard, or even amended. The applications were just determined and they were granted that leave, and they didn't amend them. So surely it's an ambush for my colleagues now to stand up and start telling you Kindiki this, Kindiki that, and therefore stay, and therefore Madhu paper this and that. 2. Number 3, my lord. What you're being asked to do is to flip-flop or to behave like a pendulum. My lord, a pendulum moves from this end to the other end, but it never leaves the two extremes, so there is what I usually call motion without movement. The court has already read a ruling to us saying that it cannot issue a conservatory order that would have the effect of suspending any provision of the Constitution. You're being invited right now to do exactly what you have just told us cannot be done, and you're told the reason you should do that is because you're human and there is a possibility you're in error. Of course, there is a possibility, my lord, you're in error, but there is a court that exists to correct errors made by this court. You're being asked to embarrass yourself to say just a few minutes ago that the conservatory order should not have issued in the first place, and then you're being invited to issue an order that would have the contrary effect. I think they are setting up the court for embarrassment. My lord, there is a reason, there is a law which we all know because both the people in the bench and the bar are lawyers. And it is common ground that no appeal operates automatically as a stay of any decision made by any court. The reason that rule exists, my lord, is so that whoever is desirous of an appeal can move the appropriate court, which they have done, and persuade that appropriate court to issue that stay. So they are telling you because there is a possibility you might be in error, therefore automatically, but the rule, if I understand it, is that no appeal, let alone an intention to appeal, can issue automatically. Lastly, my lord, you have been told about the Madhu paper injunction. I thought we were talking about conservatory orders, my lord, because Munya told us injunctions are remedies in the realm of private law. They exist to protect personal private interests, and conservatory orders, which you just said cannot issue in the circumstances of this case, are the remedies available in public law for the ordered functioning of public agencies. And because my lord has said this court has jurisdiction, if eventually you find that the Honorable Rigathi Gachagua was not lawfully impeached, this court has still confirmed it has a remedy. It can undo the entire process. Let us not detain you here, back and forth, flip-flopping, behaving like a bedlam. It is holding the court at ransom, in my view.
My lord, if I use only 2 minutes in rejoinder, the court permit me.
You will respond after Peter.
My lord, I'll just take